Okay, well, let's call the meeting to order. Roll call. All members of council are present. Our land acknowledgement is that we are in the land and surrounded by water originally inhabited by indigenous peoples and have traveled this area since time immemorial. This territory is within the lands honored by the wampum treaties agreements between the Anishinaabe and the Haudenosaunee, Lenni, Lenape, and allied nations. Peacefully share and care for the resources around the Great Lakes. Specifically, we would like to acknowledge the presence of the Three Fires Confederacy, the Ojibwe, Ottawa, the Potawatomi, and Huron-Wendat people, and the Caldwell First Nation. We are dedicated to honoring Indigenous history and culture while remaining committed to moving forward respectfully with all First Nation, Inuit, and Métis. To the members, any disclosure of pecuniary interest on the agenda is presented to you? Hearing none, thank you. Our delegations today would be Mr. Auger, our Director of Legislative Services and Clerk, and on the Municipal Freedom of Information and Protection of Privacy Act. So I will turn it over to you, sir.
Thank you, Mr. Mayor, and through you to council. This is more or less part two of what I guess we'll call the clerk's workshop. The first was back on January 25th, in which we presented on the procedural bylaw. And tonight, as the mayor referenced, this is on the Municipal Freedom of Information and Protection of Privacy Act, or MFIPA, as it's otherwise known. Certainly a subject near and dear to most municipal clerks across the province, as usually it's the municipal clerk that's assigned as the head of the institution or the head of the corporation, and with overall responsibility for responding to either requests for information or responding to privacy complaints or privacy issues that could be brought up. MFIPA truly is the title of this presentation was called the Great Balancing Act, and it really is that. It's truly a balancing act between the public's right to access and the public's and the obligation of ensuring privacy of information. As a public institution, we hold and collect and use voluminous amounts of information, some personal and some otherwise. And so certainly there's obligations that go with that. So certainly the legislation basically stated gives members of the public that statutory right to government held records. And that's certainly reflective of the fact that government is to be open and accountable to its citizens. Next slide, please. And again, that's balancing with the protection of an individual's right to privacy by regulating and putting restrictions in there with respect to the collection, use, and disclosure of personal information. Next slide. So certainly MFIPA applies to all government institutions in Ontario, not just municipalities. Next slide, and then I think we can go to the one after that. So that's just a definition of institution for the purposes of the act, of which it definitely includes municipalities. Next slide. The main principles with respect to access and privacy under MFIPA are the following. To the extent possible, information should be available to the public. Any exemptions from the public's right to access that information should be limited and specific, and I would add in there justified, should be limited and specific and justified. Individuals should have access to their own personal information and the right to collect it. So that information that a municipality may be collecting, storing, or using, individuals have a right to that personal information as it affects them. Institutions should protect the privacy of individuals with respect to personal information. And lastly, privacy complaints or decisions that are being made by municipalities on the disclosure of government information, disclosure either in whole or in part, because there may be exemptions relied upon. Those decisions and those complaints should have access to an independent review of those government decisions. And that's what the Information and Privacy Commissioner's Office, which we'll talk about in a little bit, that's their role. Next slide. So Section 4 of the Act outlines the general right of access. You'll see that the key provision, or what we highlighted there, is right of access to a record or part of a record in the custody or under the control of an institution. And that's the key provision. And as we'll learn in subsequent slides, it doesn't necessarily mean physical custody or physically under the control. It could apply to other circumstances, but definitely a right of access to those records in the custody or the control, or I guess we would say the deemed custody or the deemed control of an institution. Next slide. What is a record? The legislation provides purposely for a very open-ended and broad definition of what a record may be. So any record of information, however recorded, whether in printed form, on film, by electronic means, or otherwise. Next slide. And so as a result, employee and council emails and texts about municipal business are not private. Employee and council emails and texts about municipal business are not private. And this also extends, and this is not limited to town issued phones, town emails, town information servers. Those would normally be what you would consider as being under the custody and control. But it's certainly, and IPC decisions have certainly extended that to be applied to emails or texts from a counselor or from a employee, and it could possibly to extend to those personal emails, to those personal texts on personal devices. There's a decision I just want to quickly walk through just to sort of take some of the information from it. This decision, and I guess for the record, I'll refer to it's a decision of the Information and Privacy Commissioner of Ontario. It's order number MO-3281, and this was a 2016 decision of the City of Oshawa. And I can provide a copy of this to councillors electronically, but I just wanted to read from the main rationale from the decision. So in this particular case, an individual sought access to a series of communications that occurred between a councillor and an individual who was subsequently retained to act on behalf of the city to investigate some alleged wrongdoing by members of staff. There was one responsive record, as they say. So if there are records in response to that request, there was one responsive record, but the majority of the records, access was denied from the town on the basis that the information came from the councillor's personal email account. And so the city took the position that that's not in our custody. So the IPC disagreed and issued an order that the city grant access to the appellant to those records. So in looking at this decision, the IPC found, and I'm just going to read from a couple quotes from the review. The IPC found that the records held by a municipal councillor may be subject to an access request in two situations. The first situation is where the councillor is acting in fact as an officer or an employee of the municipality, or they're discharging some duty or something that's been assigned to them specifically by council. And in those cases, they may be considered part of the institution, and so the town has deemed access to those records. The other circumstance is even if those circumstances do not apply, where the councillor isn't necessarily acting in fact as an officer or isn't an employee of the municipality. So even if those above circumstances do not apply, the councillor's records, the councillor's records could still be considered deemed to be in the custody or control on the basis of certain established principles. And so even if the record doesn't belong to or is not in the possession of the municipality, and once again, for example, a corporate email, the municipality may still be deemed to be in custody or control, depending on some of these factors that the IPC has considered. And some of those factors would include, was the record created by an officer? What use did the creator intend to make of the record? Does the municipality have a statutory power or duty to carry out the activity that resulted in the creation of the record? And lastly, and I believe what they relied upon in this particular decision, does the content of the record relate to the institution's mandate or the institution's functions? And so certainly in this case here, the IPC was of the view that they looked at the two-part tests, and they firstly decided that in this instance that counselor was definitely not an employee in any legal sense of the municipality. And they further found that the counselor wasn't a officer of the corporation. They weren't acting on behalf of the city in any with the city's express authority. But despite that decision in the first part, the IPC again looked at whether the record was in the city's custody or control. So the commissioner considered, and I'm just going to read here from it, that the email in question related to the counselor's official responsibilities as a member of council and an aspect of council's mandate. It was clear that the record, so the details of the email conversations related to a city matter, and that the city could reasonably expect to receive a copy of the email upon request. In short, the email laid the groundwork for the city's subsequent decision to engage that investigator and the terms upon which it did so. And it played a significant role in council's decision to hire the investigator in the vote that took place later that day. They went on further, the IPC goes on further to state, unlike other cases in which the communication was found to not be in the custody or control of the municipality, the substance of the email did not relate to some purely speculative or hypothetical matter. In this case, the email played a crucial role in the negotiations resulting in the hiring of the investigator, and there was a definite connection between the agreement to hire this investigator that resulted in council's decision mere hours after those emails had gone back and forth between the investigator and the councilor. And so the main point of all that is, just to caution council, certainly to, keep those emails and texts about town business factual, professional, to avoid any kind of statements that could be considered defamatory, and certainly without breaching any kind of confidentiality, especially coming out of closed meetings. So certainly emails and texts are fair game, and again, from your personal capacity, because of the fact that you're acting as a counselor. Now, there's some exemptions, and I just want to briefly go through some of those exemptions. There's some exemptions to the requirement to disclose that information, and just want to focus on a few of these here. So the next slide, please. Sorry about that. So there's our list of common exemptions under the Act. So the first one is somewhat obvious: draft bylaws, information, and that reveals, the substance of deliberations coming out of closed meetings. Those are certainly exempt. Obviously, if the draft bylaw has been introduced in a public meeting, then that's that exemption goes away, obviously. And certainly, those deliberations from the closed meeting, if that subject matter is now and those deliberations are now being discussed in an open forum, then that exemption goes away as well. Interesting enough, deliberations and minutes from closed meetings are fair game under the Act where the record is more than 20 years old. So that I discovered that along the way. So that's draft bylaws and closed minutes. The other one I want to focus on just for a couple minutes here is, and that's your second one there. Section 7 of the Act provides an exemption. It says an institution may refuse to disclose a record if the disclosure would reveal advice or recommendations of an officer or employee of an institution or a consultant retained by an institution. And the key part in that exemption is that the institution may refuse. So it is discretionary. Whether that information can be, the disclosure of that information can be refused by relying on that exemption. And really it's to cover situations where, whether it's administration or that consultant is providing information with the intent that that information being provided to just counsel should be for just counsel, and is being provided on a confidential basis, and that confidential basis arising out of having valid concerns that the disclosure of that advice or those recommendations would be harmful if disclosed. And there could be a couple. There could be many scenarios. The exemption itself is sufficiently broad. But certainly there may be situations where, maybe administration is recommending and speaking to a range of particular options with advantages and disadvantages of that range of options. There may, by having that information disclosed, where the intent was to share it with counsel only to assist them, there may be circumstances where perhaps some of those options being recommended might put certain interest groups at a disadvantage, or perhaps other groups at an advantage. And so some of that information may be in the nature of politically sensitive information. Similarly, perhaps a situation where either a counselor or counsel as a whole, perhaps as misstepped procedurally, or not followed certain protocols, and maybe the advice and the recommendation is providing some guidance to counsel on those points. That would be typical information that there would be an expectation of confidentiality, so that it's just for counsel's ears. And again, information that there's that reasonable expectation that it could be harmful if provided for full public disclosure. And I just want to read a couple of real quick, a Supreme Court decision that commented specifically on this exemption and the rationale behind it. I can find that. So this is a 2014 Supreme Court of Canada decision. It's called John Doe versus Ontario. And I just want to read a couple of quotes from the passages. And again, this exemption is where, a municipality may refuse to disclose if the disclosure would reveal advice or recommendations of an officer or an employee. Once again, a discretionary exemption. So just quoting quickly, the purpose of exempting advice or recommendations within government institutions is to preserve an effective and neutral public service so as to permit public servants to provide full, free, and frank advice. The advice and recommendations provided by a public servant who knows that his or her work might one day be subject to public scrutiny is less likely to be full, free, and frank, and is more likely to suffer from self-censorship. Similarly, a decision maker, i.e. a counselor, might hesitate to even request certain advice or recommendations in writing concerning a controversial matter if he or she knows the resulting information might be disclosed. And again, that being said, the exemption is a discretionary one, which means that even if an institution determines that the exemption could apply, that institution may, at its own discretion, decide to release the requested records. And again, just further commentary that exemption can reasonably be applied to an incredibly wide range of correspondence containing suggestions or listing various options for a decision maker to consider. So just quickly, a few of the other exemptions, and some are fairly obvious. Law enforcement. So any kind of record where it could be reasonably be expected to interfere potentially with an ongoing investigation, reveal investigation techniques, disclose the identity of a confidential source of information, or interfere with the gathering of law enforcement intelligence. So that's an exemption that can be relied upon. Relations with other governments, section 9. So any information that this municipality receives from another level of government that was provided with an expectation of confidentiality, then the town has the right to rely on that exemption. Third-party information. So the town shall refuse to disclose a record, again, shall, that reveals a trade secret or scientific, technical, commercial, financial, or labor relations information that was supplied in confidence. And if the disclosure can reasonably be expected to prejudice significantly the competitive position or interfere with the contractual or other negotiations of a person or group or organization. Section 12, an exemption for solicitor client privilege. So whether council's receiving legal advice or having a discussion in contemplation of or for potential use in litigation. Section 13, there can be an exemption to refuse to disclose where the disclosure could reasonably be expected to seriously threaten the safety or health of an individual. And then the most commonly cited provision under MFIPA would be section 14, and that relates to personal information. So a municipality shall refuse to disclose personal information except upon or unless there's consent of the individual or in compelling circumstances affecting health or safety of an individual, or the personal information is collected pursuant to an act or under any other act that expressly authorizes the disclosure. So those are just a few of the exemptions. There are other ones, but by far the most commonly cited exemptions would be personal information. Okay, next slide, please. Excuse me. So again, we talked about this issue of custody or control. So the right of access only applies where the records fall within the custody or control of an institution. And again, as previously stated, that's not contingent upon physical custody necessarily or physical control. Next slide. So the role of the Information and Privacy Commissioner of Ontario, the IPC, they kind of have a multifaceted role. As municipal clerks, the first role, sorry about that.
Yeah, it's dry in here.
One of the key roles that the IPC plays, especially in relation to municipal clerks and in relation to requests for information under the Act, is to mediate and adjudicate appeals under the Act. But certainly they have other roles that they play. Certainly developing best practices, making suggestions and recommendations as to best practices. And that can occur formally and that can occur organically as well. Certainly in my past experience working on some MFIPA requests that have been appealed in working with officials from the IPC. Certainly there's a discussion and there could be some best practices recommended. So they've been very helpful from that perspective. Investigating privacy breaches, educating the public. I mean, a big part of that is educating the public. And, you know, that's together with, I would say, responsibility of the municipal clerks across the provinces to try to educate the public, who are trying to request information, helping them educate what their rights are, what are some of the requirements. And then lastly, reviewing and recommending changes to legislation in order to try to make improvements to the Act. If I survive, next slide, please. I won't spend too much time on the actual process, but certainly, you know, as you go throughout your term, if you have questions, certainly contact the clerk's office and we can assist you with that. But generally speaking, the process is designed on a 30-day principle. They want the legislation requests strict deadlines. And that's for a number of reasons. That's to provide, you know, disclosure to the public as soon as possible. and to assist the public. Sometimes the request for information is needed on an urgent basis. So there's a very low threshold for an application fee. And again, that's purposely low in order to ensure that full access is provided to members of the public who need information. The town has an online form, and I can provide a link after to that information but we have a standard form in which they make their request. Once that request is filed along with the application fee, a 30-day clock starts ticking on when we need to provide a decision on whether to release those records, or maybe release them in part, and if we release them in part, part of our obligation is to state the reasons and the exemptions that we relied upon. There's some provision in the Act that enables us to charge fees for the search process and for copies. Honestly, and again, the fees are purposely low in order to enhance that access, and certainly the fees do not, come close to capturing, any kind of concept of full cost recovery. But again, it's designed to open up that access to the public. But generally 30 days, there are some situations where just because the volume of information being requested is so high, or we have to consult with third parties in order to get that information, the legislation allows us to request and ask for reasonable extensions to that 30-day, but that definitely is the exception as opposed to the norm. Next slide. Receiving a request, some of the best practice recommendations, and the key one is, so when the request comes in, the municipal clerk will coordinate that request and make inquiries of the relevant departments for that information, and ask the other departments to conduct those searches. And certainly a key part of that is to, again, ensure the privacy. And one of the standard steps is to remove the requester's name and other identifying information prior to circulating that request. And that is to try to keep that request neutral and maybe not subject to any prejudice based on who the requester is. So we endeavor and try to at least use best efforts in ensuring that other departments, that the identity of the requester is not disclosed. Next slide, please. Part of all that, as that information becomes collected, the responsibility is back with the municipal clerk to review that disclosure. So it requires a knowledge of the Act to see what information should be disclosed, what information the town can rely upon an exemption. And again, it's discretionary. So there may be circumstances where we may be within our rights to request an exemption, but the town's satisfied that that information can be released. And certainly there's other situations where we think that information, if released, would definitely be prejudicial in one way or another. And so we can request an exemption or rely on an exemption. So certainly that requires municipal clerk staff to know, the exemptions. Perhaps it's some researching of past IPC orders to see how that's been decided. And really in the process of replying to that requester's original request, part of the due diligence that we require as well is to make our case on the assumption that that decision may ultimately be appealed. And certainly redactions, if there are exemptions to be relied upon, and like I said a few minutes ago, personal information, section 14 is the big one, then we need to carefully go through that information, provide the appropriate redactions from information, and create an index and an organized manner of doing that. Because again, we want to release what information we can release. We want to release that. We wanted to make it plain and clear to the requester, the information that's being provided. But as well, we're preparing, for the possibility that decision may be challenged. So the better we can become organized at the beginning, the better. Next slide, please. Appeal process. So again, if the requester doesn't agree with the final decision, he or she may initiate the appeal process by filing a written appeal with the IPC's office. And the IPC approaches it basically in 3 stages. The first stage is what I would call general intake. So an IPC officer or an employee receives that appeal request and usually informally tries to resolve it at that stage. And that's usually a call to both the requester independently, the requester and the municipal clerk, to see what the issues are and if some sort of a quick resolution can be reached. If it's not that simple and there's maybe issues to sort out between the 2 parties, then it goes to the mediation stage. The mediator will review the circumstances with both. And again, we're trying to reach an early settlement. And then failing that, it proceeds to a formal inquiry in which an IPC adjudicator will ask each of the municipality and the requester to basically make a written submission or verbal at some point, or in some circumstances, a verbal representation as to why that decision that was issued by the municipality to either, deny access to records or to deny part access to the records, why that decision should or should not be supported. And then the adjudicator will review the matter, maybe make some further inquiries, and then make a decision that is binding at that point. And then generally, just again, the importance of deadlines from the request when information requests are made. Certainly, adherence to those deadlines tends to result in fewer appeals. It certainly promotes open government, and there may be other procedural timelines involved. Maybe the information the requester needs is pursuant to maybe a future litigation matter, and certainly there'll be limitation periods applicable to that limitation matter or to that civil action or that civil matter. Okay, so in the previous slides, we spoke generally about right to access, and now we're on the other side of the legislation, or on the other side of the equation, concerning the obligation to uphold privacy. So MFIPA provides rules respecting collection, use, and disclosure of personal information. Next slide. And certainly some obvious reasons. It's a requirement to uphold privacy where possible. Certainly creates trust in that organization. It can improve the reputation of that. I don't think there would be anything worse than an organization's, either negligent or inadvertent release of information that's considered subject to privacy laws. And certainly, there's something to be said that good privacy practices means good business. Next slide. Again, we have a definition of personal information that is purposely broad and purposely wide, and it's essentially any information about an identifiable individual. Next slide. What it isn't is business information. So information about individuals acting in their business or professional capacity is not personal information. So your name, your position, records about routine work matters do not usually constitute personal information. Next slide. Collection of personal information must have legal authority to collect that information. That collection is directly from the individuals and must provide notice of collection. Next slide. So again, there must be authority to collect that personal information. So it's got to be expressly authorized by statute or for the purposes of law enforcement, or necessary to the proper administration of a lawfully authorized activity. So an obvious example is usually during election time. The nomination forms, some of the other prescribed election forms are automatically provide for that authority to collect and release and make available to the public information that would otherwise be personal information. Next slide. That's just a typical notice of collection. So you're providing disclosure of what authority that you're acting upon in collecting that information, not disclosure, and how it'll be used. and then there should be contact information if there is a complaint, or who's the appropriate person or responsible person to deal with any complaints, privacy complaints around that. Next slide. Use of personal information, either with consent or for the purposes that were originally stated. Next slide. Section 32, disclosure of personal information, again, with either informed consent for the stated person. Sometimes that information is forwarded to another officer or an employee who needs that information as part of their duties for law enforcement reasons. And then in certain compelling circumstances, that information can be released when there's a reasonable concern related to health and safety. And then the act provides for certain compassionate circumstances, but generally speaking, with informed consent, and that's typically at the time that information is obviously being collected. Next slide. So again, just a continuation of what's not considered a disclosure of personal information, and that relates to information more in the business sense. A job classification, a salary range, benefits, employment responsibilities have been held not to be personal information. Certain personal information about a deceased individual disclosed to the spouse or close relative, again, along the lines of compassionate reasons. And then lastly, or almost lastly, next slide, under privacy breach management. Certainly the recommendation from the IPC is for institutions to develop a comprehensive privacy policy and or review an existing one that outlines the institution's commitment to the protection of privacy and how the institution will be compliant. And the legislation, next slide, the legislation does have some teeth. There's this possibility of fines up to $5,000. Generally speaking, because the main goal of the IPC is to ensure compliance, that compliance is maintained, and to promote corrective actions to be taken. So there is an exemption from the from being fined if it can be demonstrated that the institution or the defendant, as they call here, was acting in good faith, and yet there was still a breach. There was an inadvertent breach. Likely coming out of that would be remediation or corrective measures for the institution to take as part of that. So certainly, breaching, releasing someone's personal information has some consequences. Probably some of the more important consequences is, that loss of public trust and potentially negative exposure, negative media exposure surrounding that. So that's the general overview. I'd be happy to try to answer any questions, and certainly and not just in this capacity, but going forward through council's term. If you have questions, or even if you need to direct a resident who's looking to obtain information, for sure, direct them to the clerk's office. I'll provide as well a link to the standard form that the resident would need to provide. And depending on the type of information, it may be information that has to be requested through the act, but there may be, it may just be standard information that the corporation or the town has already developed a policy of releasing. So it just depends on what that information is. And that's about it, Mr. Mayor.
All right, thank you very much. Any questions or comments? Yeah, go ahead, Councilor Houston.
Thank you, Your Worship, and through you to Mr. Oj. I've got a couple questions. So in regards to any FOI requests, either for council information or if any of our records are being requested, to my knowledge, and I'll knock on wood, that hasn't happened in my previous 8 years, but if that does happen, are we notified that this is going on right? I'm just curious because it hasn't happened, but should there be a request asking for either council information or any information regarding council? Is that something that we are notified of?
Through you, Mr. Mayor. Yes, that would be part of it because some of that information that may be relevant to the request, even though the town may be deemed to be in custody or control of that information, the actual records may be with that counselor. Some of those emails, some of those texts may be from personal emails, for example. So they would, just like we would contact other agencies of the town, I think the counselors would be brought into that and contacted and reminded of their obligation to provide that information as part of a request. So yes, I think that's definitely a potential.
And thank you. My second question, just regarding maybe a best practice. And I know, we've recently come out of a campaign and from time to time, just from previous campaigns, I still receive emails to a campaign email, right? Or a personal email that I may have used during a campaign. And I'm just wondering from a best practice perspective, and what I've done is I take that email, I forward it to my town email, and then I can forward it off because I don't have our contacts in my personal email. I'm just wondering about a best practice. If a resident, emails my personal email, should I tell them, please email my town email, or am I okay to forward that myself to my town email? Right. I'm just wondering from a records perspective, what is the best, or what you may recommend?
Through you, Mr. Mayor, ultimately, I think the direction to the citizen would be to because especially, obviously if it relates to town business, it should be for those emails to hit your counselor email. But certainly, yeah, in those one-offs, if you have them go into your personal, I don't think there's anything wrong. And in fact, I think it's some due diligence on your part to send that to the town email, because certainly it may become a series of emails, and now it's on the town server. So that would, in the event of a request, that would make perhaps IT's job a little bit easier in that respect. So I think that's a good recommendation that you have.
Thank you, Mayor. Just a question on the custody and control. So in terms of custody, if you have a cell phone that's not town given and it's personal, how does the FOI work for that? You kind of touched upon it, but I'm
Through you, Mr. Mayor.
My next question.
Through you, Mr. Mayor, and to the deputy mayor. Are you referring to, I guess, a situation in which so it's on a personal email or a personal device? I think for purposes of determining whether that's under care or custody, one would need to look at the substantive part of the email. So is there a discussion about actual town business? Is the discussion concerning perhaps town business that is currently under deliberation or about to be? Certainly there may be the possibility of claiming an exemption if they're general statements and not necessarily relevant or not necessarily directly on point with current council business. But if it relates to matters as well, and that was part and parcel of the rationale in this City of Oshawa decision, if part of that, if the part of the contents of that email relates to matters that council's mandate or council has the authority to make decisions upon, I think that becomes fair game for disclosure purposes. So not a direct answer, but it really does relate to the content. But definitely the point that was being made back in 2016 is that there's definitely no longer this clear division between councilors' personal and councilors' town emails and texts. They're both fair game.
The reason I ask is I know the school board, for whatever reason, in terms of that custody control, They used to provide cell phones to principals and whatnot and administration. And they came to the conclusion where they're going to give an allowance. And the employee would go out and get their own phone. But there's that overlap. You're actually doing work related on that phone. But their rationale was if they had an FOI from, say, the Windsor Star, the media, that's their personal phone, it made it more, I don't know, it made it more difficult. They couldn't access it as easily as if it was controlled custody of the school board itself. But that's good. Thanks for, delineating that. And I know even here, I've had maybe one FOI, that bingo issue. Other than that, do we know about them? Or like Councillor Houston asked, do we have many FOI requests come in? I don't see a lot. Usually it's the media, sometimes the Windsor Star, we had one on a development, I remember a few years ago, but other than that.
Through you, Mr. Mayor, to the Deputy Mayor, I think generally speaking, we don't have a large volume of requests. But certainly, that number could always go up, or you could have maybe 2 requests in a year, but the requests are so voluminous that it's going to take up a considerable amount of administrative time. But based on some of my conversations, as you know, I've only been with the town for a short period of time. It doesn't appear that the town has had a large number of requests, and that's good.
And that would apply. I mean, we did a lot of discussion on phones and so forth, but even your personal computer at home and laptop, anything that's on there that states any municipal business and so forth, as well as has that access. My question, you made a reference about regardless of some of the information that the exemption piece, beyond 20 years, then it just becomes available.
Through you, Mr. Mayor. So that particular, I guess, exemption to the exemption was in relation to your closed meeting items, your closed meeting minutes. There is that exemption only applies the way I read the provision for a 20-year period. So closed meeting deliberations are potentially fair game when that record's over 20 years old. And so that, to a certain extent, that speaks, that speaks to records management, that speaks to having a properly prepared retention bylaw. So all those issues are definitely interrelated.
In the 20 years, it would be if there's something that's, and one of them is, the bingo issue, for example, where it's been, I forget now how many years, it has been in that. Is it from the time the closure of, so it'd be if there was a meeting and it was done and it's July of 2003. So, but it closed at that time. So within that 20 years, somebody could request that July 3rd particular meeting, even though there's some ongoing.
So through you, Mr. Mayor, if somehow that record, so my understanding is that it'd be 20 years from the creation of the record. But if there is any kind of ongoing litigation that hasn't been resolved, then that could not be released.
Okay.
Or potentially, maybe you have litigation that has now reached settlement, and maybe part of that settlement is a non-disclosure of the minutes of that settlement. So there are circumstances where, even though that 20-year exemption to the exemption is there, it may not potentially still be released.
Not a hard stop like that. Okay, any further questions or comments? No, this is really interesting. I mean, it's I think it's not only you can see that even ourselves as stewards of the municipality and it's important enough and complex enough. You can imagine now the general public themselves to know exactly, what this legislation is all about. So these are good exercises, and I think it's something that not only should be, parked, and every 10 years we do it, it should be kind of a review. And in particular, if there's anything that obviously comes through municipal affairs, they're always looking at improving or changing and nudging and so forth. So to keep us certainly apprised, and I guess the whole lesson here is that you don't need to carry 4 different iPhones, because they're all going to be subject to the to the same fee. So save yourself some money and dealing with that. So again, thank you very much, Mr. Ogier, for obviously this I think very worthwhile exercise that we've just done this afternoon. No further questions or comments at this stage, and if I could have a motion to receive the report as presented, Councillor Toniol and Councillor Higginson. On the report, all in favor, opposed, if any, that is carried. And there was no communications to deal with. If that's it, adjournment is now recommended. Councillor Houston move, and Councillor Toniol support. All in favor? Opposed, if any, that is carried. This meeting is now adjourned. Thank you.